The courtroom felt unusually contained that morning. Not silent, but controlled, like everyone inside was carefully managing their reactions. Pens moved slowly, chairs shifted only when necessary. Even the air seemed heavier, as if waiting for a single piece of information to decide which way the room would turn. Daniel Mercer stood at the plaintiff's table with deliberate composure. His posture was careful, not rigid, and the medical brace around his lower back looked professionally fitted rather than improvised. A cane rested near his hand, not clutched, but available, like an object he was used to being seen with rather than relying on constantly. When he spoke, his voice carried restraint. "Your Honor, I didn't expect my life to turn into this. The injury changed everything. I lost my ability to work normally, and I've been trying to manage pain and function since then." There was no exaggeration in his tone, no emotional performance, just controlled explanation. The kind that doesn't demand belief, but doesn't immediately invite disbelief either. Across from him, Lisa Hartman sat upright, hands interlocked tightly. Her exhaustion wasn't dramatic. It was accumulated. Months of legal pressure, financial strain, and the slow erosion of her business had settled into her posture. When she spoke, she didn't look at Daniel. "I built my company from nothing," she said quietly. "When he told me about his injury, I adjusted everything. Reduced workload, restructured jobs, covered costs. Then things started not adding up." Her attorney leaned forward, opening a file with practiced efficiency. "Your Honor, the plaintiff's version of events is contradicted by multiple independent records." Judge Judy didn't interrupt. She simply gestured once. "Proceed." The first evidence was a workplace report summary. Brief, clinical. Daniel's movements at the site were described as cautious but functional. No immediate indication of collapse or emergency response. Daniel's attorney, a composed man in a dark suit, stepped in smoothly. "Your Honor, those observations are being taken out of context. My client was on prescribed pain management medication at the time, which allows intermittent mobility. Pain does not always present externally. It was a strong framing. Calm, technically plausible." Judge Judy glanced at him briefly. "Understood," she said. "We'll address that." Lisa's attorney stood again. "Then let's add medical records." A second file was opened. A neurologist's report appeared on screen. Not dramatic language, just clinical contradiction. Patient reports severe spinal limitation inconsistent with observed biomechanical output during external physical activity records. Lisa's attorney didn't explain it emotionally. He didn't need to. He simply looked at Daniel. "Your doctor states your injury restricts you from sustained load-bearing activity." Daniel didn't react immediately. When he did, it was controlled. "Doctor assessments are based on presentation during consultation," he said. "They don't account for recovery, variability, or episodic improvement." A subtle pause. Then he added, "Chronic conditions fluctuate." It was intelligent, structured, and difficult to dismiss outright. Judge Judy finally spoke. "But your own treatment notes show no documented improvement phase, consistent with high-intensity physical exertion." That landed differently. Not loud, just precise. Daniel's attorney shifted slightly. "Your Honor, those notes are incomplete without therapy context." He opened his own folder. "My client was enrolled in a supervised rehabilitation program designed specifically to rebuild spinal stability through resistance training." This was the pivot Daniel needed. He nodded once. "That's correct." "I followed a structured recovery plan." For a moment, it held. Then Lisa's attorney leaned in. "May I ask one question?" Judge Judy nodded. He turned slightly toward Daniel. "Your recovery plan included competitive-level deadlifts." A pause. Daniel answered carefully. "Progressive resistance training, yes." Lisa's attorney immediately responded. Then, why does your therapist's sworn statement say he explicitly advised against heavy axial loading due to risk of permanent neurological damage? That shifted the room. Not emotionally, but structurally. Like a support beam had just been exposed as compromised. Daniel's expression didn't break. It adjusted. My therapist is referring to early-stage recovery guidelines, he said calmly. Protocols change as condition evolves. It was a smart defense, adaptive. Hard to pin down. Judge Judy turned slightly. Let's clarify that. She signaled the bailiff. A new document was brought forward, a signed affidavit from the treating physiotherapist. It was short, direct. No authorization was given for high-load strength training. Patient was advised repeatedly that such activity was contraindicated. The courtroom temperature felt different after that. Not colder, just more focused. Lisa's attorney didn't pause. Your Honor, there is also a pattern. He placed another set of documents down. Mr. Mercer has filed 3 prior injury claims in the past 4 years, all involving workplace incidents, all involving large compensation demands, all settled before full trial review. Lisa finally looked at Daniel, not with anger, but with something closer to exhausted realization. Daniel's attorney immediately responded. Objection to relevance of prior civil settlements. Judge Judy cut in instantly. Overruled. Pattern is relevant. Daniel exhaled once, slowly, still composed, still functioning. But now the structure around him was no longer stable. It was being reconstructed in real time, piece by piece, without emotional escalation, just documentation. Lisa's attorney continued. In each prior case, similar injury claims were made, similar mobility restrictions. Similar rapid financial settlements followed allegations of negligence. He looked directly at Daniel. Is it your position that all of these incidents involved separate, identical injuries? Daniel answered without hesitation. My position is that multiple incidents affected pre-existing vulnerability. It was a refined answer, carefully insulated. But Judge Judy tilted her head slightly. Conveniently consistent vulnerability, she said, not accusatory. Just observational. Then came the final exhibit. The bailiff placed a sealed medical compliance record on the bench. Judge Judy opened it herself. The room shifted subtly as she read. Then she looked up. Mr. Mercer, she said, this is a full rehabilitation compliance report from your assigned treatment facility. Daniel's attorney straightened. Your Honor, that document supports my clients. Judge Judy raised a hand. No, she continued reading. This report states the patient demonstrated full-range spinal mobility under load-bearing conditions exceeding clinical expectations for his diagnosed condition. A pause. Then she added quietly, including supervised treadmill sprint testing. Daniel didn't speak immediately. For the first time, the timing of his silence mattered. His attorney leaned in slightly. Your Honor, that reflects controlled therapeutic progress. Lisa's attorney responded immediately. Controlled? Or incompatible with his claimed disability? Judge Judy looked at Daniel. Explain the contradiction. Daniel finally shifted, just slightly. And when he spoke, his tone was still controlled, but narrower now. Rehabilitation requires testing limits. That doesn't negate injury status. It was still smart, still structured, but now every explanation required layering. Nothing stood alone anymore. Judge Judy closed the file, then said, simply, it does when those limits exceed the condition you claim exists. That was the first crack that wasn't about evidence. It was about alignment. Lisa's attorney added the final layer. Your Honor, there is one more document. He placed it down. Internal insurance review notes from a prior settlement involving Mr. Mercer. He didn't elaborate. He didn't need to. Judge Judy read silently, then spoke. This indicates prior claims were flagged for inconsistent symptom reporting under similar circumstances. Daniel's attorney tried one last time. Those were administrative observations, not conclusions. But even he didn't push it further than that, because the pattern was now fully formed. Not one incident, not one misunderstanding, a repeated structure, a system. Daniel finally spoke again, but more carefully now. People interpret recovery differently. That doesn't make every variation fraud. It was his strongest remaining position. Judge Judy looked at him for a long moment, then replied quietly, "No, but repetition without consistency does." That was it. No dramatic shift, just closure forming. She turned to the bench record. This court finds the plaintiff's claims unsupported by credible medical evidence and contradicted by documented physical capability exceeding stated limitations. A pause, then final. Case dismissed. A single strike of the gavel followed, not loud, final. Lisa didn't react immediately. She just sat back slightly, shoulders loosening, not in victory, but in exhaustion finally releasing its grip. Months of pressure didn't turn into celebration. Just relief that something had ended correctly. Daniel remained standing for a moment longer than necessary, expression contained, already transitioning mentally from courtroom defense to legal aftermath. Outside this ruling, Judge Judy added without looking up, "This matter is referred for formal investigation into potential insurance and civil fraud based on pattern evidence." The courtroom began to reset slowly. Papers collected, chairs shifting, systems moving forward again. Lisa gathered her documents with steady hands, pausing only once as if confirming the reality of what had just happened. Not justice as spectacle, justice as correction. And behind her, the weight of what Daniel Mercer had built over multiple cases was no longer narrative. It was now record.